Thank you, Mr. Speaker. I rise this afternoon to speak
10 minutes left on
in
the
favor.
debate time.
Thank you, Mr. Speaker. I rise to speak in favor of this bill because I believe in the process that is our legislative process. I believe that process is one that engenders good legislation after deliberation. And we have heard from members of the minority party seeking to add amendments to the bill. And I know that the commitment of the sponsor is that he will continue to do that. The sponsor has made commitments to me that he would continue to look at the advertising sections of this bill. I rise also to provide some education to the members because I want you to be aware of 3 amendments that were proposed in the subcommittee. Those are on your desk with my card at the top. These are not proposed amendments for you to consider today. These are just for your consideration as this bill moves forward, and I hope that the sponsor will reconsider his position on some of these amendments, specifically as it moves over to the Senate, and I hope it does today. The first one dealt with exactly what Chairman Knight raised, allowing for regulation through the pharmacies. We have an opioid epidemic across this nation because they were not regulated tightly before. And then we had to pass prescription drug monitoring legislation to monitor that. And yet now we're having our Attorney General file a lawsuit to prosecute for the misrepresentations made by manufacturers of opioids in this state. You can see that this cycle moves in a direction that is not for the well-being of the state. Having pharmacies involved would help to regulate this even tighter than it currently is under the bill. And mind you, the pharmacies would be tied to and have to adhere to the same requirements as the licensees if this was added. The second section of the amendments that I had proposed in subcommittee deal with advertisement. It is a federal violation to advertise the sale of a Category 1 substance. So if it's a controlled substance Schedule 1, it is illegal under Title 21, Section 843 to advertise in any way, even specifically the internet, for the sale, use, or distribution of a Schedule 1 substance such as marijuana or the THC oil. And so I had asked for that to be the advertising section of this bill, lines 541 through 557, to be struck because it condones advertisement. It authorizes and allows for advertisement when the federal law says the exact opposite. I think that that needs to be removed from the bill through the rest of this process. And then finally, I'd also added an amendment and asked for consideration on the ownership interest of those who are seeking to a license in the state, and that those that are engaged in recreational marijuana sale or manufacture in other states would not be allowed to have a license in this state. I rise because those are, I think, significant issues that need to be resolved in the bill as it moves forward. I do appreciate that the author has spent great time and great energy on tightening this bill up as it has gone through the process, and I hope he will do so even further. It's important to know that there are only 2 patent strains of marijuana in the U.S. One is held by the United States government, and another one was just recently patented. Otherwise, all different strains of marijuana that are being grown are not patented. They can be used in other states, could be grown here in the state of Georgia. And I hope that as this bill moves forward, we will work to perfect it, improve it, but I do encourage you to vote for it because I trust that the sponsor of the bill and I trust our legislative process will work to slowly but surely make it as good of a bill as we are humanly possible to do. Thank you, Mr. Speaker. I yield the will.
Chair recognizes Representative Turner to speak to the bill.
Thank you, Mr. Speaker. I want to speak briefly to, especially if you're new here. If this is your first term and this is your first year and you've been contacted by some people back home who are really influential in your local community, I'm talking to you. I want to talk to you guys. I want you to hear my voice on this. There are people who are very influential back home for you, right? I have one of those people. His name is Frank. I love Frank. Frank was first elected in my county. He's the most popular person in my county. He was elected in 2016. And I have a great relationship with Frank. Frank emails me and he says, I want you to vote against this bill. I had to call him back and say, Frank, I'm one of the top 6 sponsors. So we had to have this conversation about why I was for it and he's against it. Most popular man in my county. Everybody loves Frank. Frank says to me, Scott, I'm worried about the slippery slope this creates. I'm worried about the fact that we're going to have recreational marijuana in 3 or 4 years from now if we let this thing pass. And I say, Frank, you know that's not my heart. You know that's not why we're doing this. You know we have a constituent, her mom sitting up here in the gallery. We see you. She's been advocating for her daughter for years. She had to go all the way to Colorado for months on end so she could get access to this medicine, and we finally passed Haley Hope's Act. And we're trying to make it so she's not a criminal for obtaining that medicine, Frank. I love you, Frank. I love you. But you're not in my oath of office. When somebody who's the most popular person in your county tells you, please don't vote for this, your oath of office does not include their opinion. They didn't get elected to do this job, you did. And so I'm asking you, please set aside that concern that's without merit and allow our patients to have access. Do what you think is right for your constituents, not what somebody else thinks might happen later on. Do not yield to fear, uncertainty, and doubt. Thank you, Mr. Speaker.
Chair recognizes Representative Dukes to speak to the bill.
Thank you, Mr. Speaker, and thank you all for indulging me in this moment. First of all, I want to thank the author of the bill because he has worked tirelessly in trying to perfect legislation for the state that addresses an issue that is very close and dear to the hearts of many. Our state has about 6, 7, 8,000 individuals who are in dire need of this drug. They do. I probably would not have come to the well if my question has been answered, and that question is there any other way that this state can satisfy the needs of those individuals without the state of Georgia having to go into the business of planting, cultivating, harvesting, manufacturing, and distributing this drug? Is it possible that we could have bought it from Colorado or from California or the state of Washington? Was there any other way to satisfy the needs of our constituents who we truly, truly want to help? But it seems as if this was the position of the General Assembly, that in the state of Georgia, we didn't really want to take that particular position. We wanted to be able to sell, distribute, manufacture, plant, cultivate. And since this is the will of, or perhaps of this body, then I took this position and added to it. If we're going to sell it, if we're going to get in this business, we're going to sell it, we're going to manufacture it, plant it, and grow it, then since from my community we make up a little bit better than a third of this state, is there going to be any provisions for my children or people who look like me to be able to participate in this endeavor? Will they have a license? Will they have an opportunity to plant, distribute, manufacture, grow, and sell marijuana oil in the state of Georgia, since this is what we're going to do? My contention is that I think they should. If we're going to go into the business of selling this drug, then every community in Georgia should have an opportunity to bear the prosperity that this industry is going to produce. Now, a lot of people say that perhaps what we should do is, we're going to be fair. We're going to make sure that this process is inclusive. But if past experiences is an indication of future performance, I have a problem with that. Because we do have a disparity study that is associated with the DOT. Whereas that you're supposed to use so many people from this community to participate in the paving of the roads in this state. And DOT, under its disparity study with everything that the feds say, spends about 3% of the transportation money in my community. That troubles me. And hopefully it should trouble you. Because the only way we can get to where we need to be in order to make Georgia, Georgia for everybody, everybody has to participate in the economic prosperity that this state provides. So could have gotten the drug from somewhere else? Perhaps. We don't grow poppy. But we get Percocets, we get morphine. Could we have gotten it from someplace else? Perhaps we could have. But if we were going to get it from somewhere else, and we were going to do it here in Georgia, then I think it should have been an opportunity for all of Georgia. From South Georgia, North Georgia, East Georgia, West Georgia, all over the state of Georgia, all of Georgians should be having opportunity to be selected. In the process upon selecting all of Georgians now is gravely flawed. Mr. Speaker, if there are no questions, I will yield the well.
You have a question or two if you care to yield, but you don't have to.
Mr. Speaker, I never do, but I'm going to take one.
Going to take one.
Maybe two, if it's a good one.
Chair recognizes Representative Bennett to your left for a question.
Thank you, Mr. Speaker. Will the gentleman yield?
Yes.
Is it not true that one of the missions of the Georgia Legislative Black Caucus is to decrease the gap and disparities, both economic and health, in the state of Georgia?
That is true. We have some real serious problems in our community. And most of it comes from the fact that we are not able to develop a business structure within our community that supports that community. The biggest corporation, there is no one in the state of Georgia that has the budget of the state of Georgia. No business. But when it comes to our community and being able to share in the prosperity of that, in the procurement of that, it is less than 2% that we get back from the state. So yes, we are working hard for those, to work through those disparities, and we feel as if that money coming through our communities and developing business enterprises will solve a lot of problems that this state has and those communities have. Thank you.
Would the gentleman further yield?
I took a long time to ask the question. Yes.
Thank you so much. Is it not true that the Georgia Legislative Black Caucus also supports the Georgia as being the #1 place to live, work, and play?
Absolutely. We all for that. Yes, ma'am.
As well as to decrease the disparities that exist among the people. Thank you so much.
Absolutely. Mr. Speaker, I'll yield the well. Thank you.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Chair recognizes for the chairman's time, Chairman Allen Powell. By rule has 20 minutes.
Thank you, Mr. Speaker and ladies and gentlemen of the House. I'm not going to take 20 minutes, but I just want to call attention to the process and how this all and everything has transpired. And I can't tell the members of this House how they need to vote. That's in your heart. That's in your soul. I will tell you that 4 years ago, that when former Representative Peake and a lot of others, when they started this issue, it was all about children with seizures. It was about those other people that it developed over the years. For the last 4 years, we've passed legislation and we made it legal for those citizens with certain diseases and certain ailments to be able to obtain low THC oil. And I'm not talking about the oil that's got the feel-good stuff in it, because it's been boiled down, pressed, ever how they do it, and they've got this substance. And I don't know if it tastes like castor oil, I don't know what it tastes like, but if it works, so be it. But I want to read something to you. I asked the committee the other day, one of the members, to read this, and this is in the Section 2 of the cannabis oil bill that we passed years ago. The General Assembly finds that thousands of Georgians have serious medical conditions that can be improved by the medically approved use of cannabis, and that the law should not stand between them and the treatment necessary for life and health. You know, to me, that just about says it all. I can tell you for a certainty that the only thing that I can possibly imagine that would be worse than to be in pain and constant pain from the seizures or Parkinson's or cancer or ALS or any of these type of disease. The only thing I know that could be worse than that would be to watch the ones you love suffer from those diseases. And what would make it worse than that would be to see the children that suffer from these seizures. And that's what the whole intent that started this 4 years ago. Now we've got some folks, and I can't tell you that they're just going through the process. I respect our law enforcement professionals, but I'm disagreeing with them on this. Their position has been that this is just the next step towards recreational use. Well, I hate to tell you folks, you got recreational use today. There's probably more pot that's growed in back porches and everything else, because I got to tell you something. When we passed this 4 years ago, how did these folks get the cannabis oil? If they were fortunate enough that they had a source that was bringing it from out west or some of the other states, they did it. I heard tales of how they used to, some of the families of these children used to have Saturday morning cooking parties where they bought the pot and they put it in whatever, and they boiled it down, they pressed it and all of that. Sort of like the old-fashioned Tupperware parties for those of y'all that are old enough to remember. But I want to tell you something. I go back to what I said. If you have a loved one and they're in pain, you will do whatever you have to do. Now, there's been some folks up there that's a lot smarter than I am. The Dean of the House, Calvin Smyrie, says it about as well as anybody. Dr. Newton, professional, knows more about the medical sciences than I ever will. And that's the way, and it's a good thing he does, because the only thing I know how to do is self-medicate from the Al Williams School of Medicine. But ladies and gentlemen, the end of the world will not come regarding how you vote on this. But I'm going to tell you something. Remember this. You have one reason that you're elected, and that's to do what's right. To do what's right. And if that means helping somebody to provide that cannabis oil that's been refined down so that they don't have to depend on bootleg or whatever they have to do to get what they need. But this bill, and I commend Mr. Gravely, but this bill does not give any inclination to me of leading toward recreational use. I will tell you, if anything else, it ought to tighten it up even more, because this is such a rigid bill. And you know, I'm like a lot of y'all. I've had people that says back home, you know, gosh, I want me one of them licenses where I can grow that stuff. And I laugh at them, and I think to myself, I said, boys, do you think you're going to be able to grow this pot like you growed watermelons and the kids jump over the fence and get it? No. This stuff's going to be so tightly controlled in probably hydroponic conditions. It's restricted, folks. It's tight. But at the end of the day, it's only about one thing. One thing, and that's carrying out the bills that we have done for the last 4 years that were hypocritic to me, that we passed bills to let this substance be available to the sickest folks that needed it the worst, but yet we didn't give them access to get it. And this gives them that access. And there's nothing in this bill that would further the recreational use. Ladies and gentlemen, vote your conscience. But I encourage you to give this a favorable consideration so that we can see if it can be improved across the hall. Thank you, ladies and gentlemen.
There is an amendment to the bill. It is AM 331866. The clerk will read the amendment.
Gravely Powell offer the following amendment. Amend the House Committee on Regulated Industries, substitute to HB 324, LC 363941S, by striking line 193 and inserting in lieu thereof the following. Subsection B, the Oversight Board shall comprise 12 members as follows. By inserting lines between lines 195 and 196 the following. The Director of the Georgia Drugs and Narcotics Agency or his or her designee.
Is there any objection to adopting the amendment? There is an objection. Does the gentleman move? Does the gentleman move? Gentleman moves. All those in favor of adopting the Gravely amendment, AM 331866, will vote aye. Those opposed to the amendment will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the adoption of the amendment, the ayes are 100, the nays are 65. The amendment has been adopted. Is there any objection to adopting the committee substitute as amended? The chair hears none. The committee substitute as amended is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of House Bill 324 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. What purpose does Representative Morris rise?
Parliamentary procedure.
State your inquiry.
Request to be excused for this vote under Rule 133. Or not.
I can't wait to hear the backstory, but the gentleman has that right. The journal will so reflect. All in favor of the bill are voting aye. Those opposed are voting no. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 324. The ayes are 123, the nays are 40. This bill, having received the requisite constitutional majority, is therefore passed. The clerk will read the caption to House Bill 446.
House Bill 446 by Representative Knight of the 130th and others to be entitled an act to amend Code Section 48.7, 40.36 of the Official Code of Georgia annotated relating to income tax credits for timber producers incurring losses from Hurricane Michael. This bill having been referred to the Committee on Ways and Means, that committee recommends that this bill do pass.
Chair recognizes Chairman Knight to present the bill.
Thank you, Madam Speaker. If you will remember, back in special session, we passed a relief package that included a $200 million credit to the victims of Hurricane Michael. Specifically, that credit was in regards to the timber tax. It was the forestry and the farmers there. Our intention was to make sure that as much of that $200 million got back to the victims, the farmers, the folks who incurred the casualty losses. And so we put in a refundability, the credit is a refundable credit. I think inadvertently going back and forth, we also put in a transferability clause in there so that it could be transferable. But what we did is we made the refundable credit transferable. That is bad tax policy. What this bill seeks to do is it retains the refundability of that credit directly to the casualty loss, in other words, the farmer that was part of the hurricane, that had casualties as a part of Hurricane Michael. The farmer or the casualty loss person can transfer those credits, but the refundability does not travel with the transfer. It's just a regular credit at that point that can be used to offset any liability at that point. That's all this bill does. This makes for good tax policy, and it makes sure that those people are expected to hit hardest with the Hurricane Michael with the ag industry, that we give them as much opportunity as we can to get as much of that relief back in. And that's what this bill does. Madam Chair, or Madam Speaker, I'll stand for any questions. If not, I'll yield and ask for favorable consideration for House Bill 446.
There are no questions.
Thank you.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of the bill. The yeas were 162, the nays were 0. The bill, having received the requisite constitutional majority, is therefore passed. For what purpose does Representative Carson rise?
Madam Speaker, pursuant to Rule 133, I ask to be excused from this vote.
The gentleman has asked to be excused from the vote pursuant to Rule 133, and he has that right. The record will reflect. Clerk will read the caption to House Bill 387.
House Bill 387 by Representative Lumsden of the 12th and others, to be entitled an act to amend Code Section 44-14-320, the official code of Georgia annotated, relating to certain liens established and removal of non-conforming liens so as to provide for liens in favor of private, nonprofit, volunteer fire departments. This bill having been referred to the Committee on Judiciary. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Lumsden to present the bill.
Madam Speaker, members of the House, I bring to you House Bill 387. This is a bill that deals with private, nonprofit volunteer fire departments and conforming liens. Approximately 25% of the fire service in Georgia is provided by private, nonprofit volunteer fire departments. Most are structured as 501c(s). A substantial number of those are subscription-based services. Property owners who subscribe to the service pay an annual subscription fee, and in the event of the fire, the department responds. Property owners who do not subscribe may request the fire department respond to a fire, but they do so knowing that they are responsible for costs associated with putting out the fire. In the event the owner does not pay for the service requested, then the bill simply provides for a means of collecting at a future date by placing the cost of the service on the list of conforming liens as listed under Code Section 44-14-320. That is the bill. That's all it does. I ask for your favorable consideration. I'll take any questions.
There are no questions. The gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machine. On the passage of the bill, the yeas were 163, the nays were 1. The bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 345. House Bill 345.
House Bill 345 by Representative Cooper, the 43rd, and others, to be entitled an act to amend Article 1 of Chapter 1 of Title 42 of the official code of Georgia annotated relating to inmate policies so as to provide for prohibited practices relating to a pregnant female inmate or a female inmate who is in the immediate postpartum period. This bill having been referred to the Committee on Health and Human Services. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Cooper to present the bill.
Thank you, Madam Speaker. Ladies and gentlemen of the House, I bring to you the committee substitute to House Bill 345. Sometimes we rock along and we don't realize what's happening across our state. both good and both bad. And you can imagine how shocked I was when we were up in Athens in December to have someone come up to me and say, do you know that they are still shackling female prisoners when they're pregnant and even when they're in the delivery room? And I went, what? Not in Georgia, not in this day and age, but it's true. We're still shackling women prisoners across this state. You know, now not so much in the state's penal system, but with some of our sheriffs in the smaller places around our state and some other facilities where we have prisoners confined. So that is why today I bring you a bill to stop that practice in our state. It is inhumane to shackle a pregnant woman. So this bill would make it where you would not be able to shackle a woman in her second and third trimester of pregnancy. It lays out the definitions and about our penal institutes, and it says there are a couple of exceptions, not where you shackle them with chains, but if they need to be restrained, that you do it if it's an immediate or serious threat of harm to herself, the staff, or others, or if they are a substantial flight risk. And if you do it by restraining her hands in front of her so that she is still able to walk and without throwing off her balance, as happens to many pregnant women. I will tell you that this is supported by the Georgia Life Alliance. The sheriffs do want me to make a slight adjustment to the reporting, and I will be glad to tell them I will do that on the other side. But this is a step in the right direction for Georgia, and I'm ashamed to say that Alabama's practices and all they do and how they take care of pregnant women far exceeds ours, and we got a lot of catching up to do if we're behind Alabama. So I would ask for your favorable consideration of House Bill, the substitute to House Bill 345. And Madam Speaker, if there's no questions, I will yield the well.
There are no questions. The lady has yielded the well. The chair recognizes Representative Dreyer to speak to the bill.
Thank you, Madam Speaker. First, I want to thank Chair Cooper for bringing this bill, for shining a light, and for being a voice for so many people that don't often have a voice. I want to begin by also complimenting our Georgia Department of Corrections, both Commissioner Dozier and the current Commissioner Bryson, who have this policy right. They do not shackle women in prison unless they are a flight risk or a danger to themselves or others. And I've done open records requests for the Department of Corrections, and guess what? They haven't had to shackle anyone in the last several years. It is a good policy. They haven't had anyone flee while pregnant. They haven't had anyone hurt anyone while pregnant, though they still have that option. And still they don't have to shackle. I've personally spoken with women that have been shackled while pregnant. I've personally spoken with women that have shackled while delivering. And I've personally spoken with OBGYNs in Georgia who have delivered babies while the mom was shackled. This is a conservative idea. Congressman Doug Collins recently passed this in the First Step Act in Washington, D.C. This is also, this exact bill that Chair Cooper is carrying is supported in writing by the American Conservative Union. There is fortunately a national bipartisan coalition around this issue. And I'll just say one more thing. I started working on this and I ran into someone who's become a very good friend of mine, Pamela Wynn, who Chair Cooper recognized earlier. Pamela Wynn was incarcerated in Georgia. It was a drug crime. She made a mistake. When she was incarcerated, she was pregnant. Her feet were shackled. She was stepping up into the van for transport. And while her feet were shackled and while she was pregnant, she fell and she injured herself. Took her 4 weeks of demanding medical care before they took her to the hospital. When she got to the hospital, the doctor, attending physician, said, no, you need an OBGYN. But she wasn't authorized to have one, so they took her back to jail. 4 weeks later, they got her to see an OBGYN, and they said, no, we need to do an ultrasound, but she wasn't authorized for one, so they took her back to jail. So approximately 12 weeks after she injured herself, while she was in medical watch, and I want to be clear, medical watch is solitary confinement, my friend Pamela Wynn miscarried in the middle of the night while she was in solitary confinement. We have a policy that is inhumane in Georgia, and that is hurting mothers and babies. And we have an opportunity to do something important today. The final thing I'll say is, every woman right now that delivers while incarcerated spends 1 hour with her baby the day she delivers. The baby's removed from her. The next morning before she goes home, she spends 1 more hour with her baby and the baby's removed from her. And that woman is typically sent back, that mom is typically sent back to jail where she's in medical watch. Medical watch in prison is solitary confinement. You will have postpartum women who have just given birth and had their children removed from them, oftentimes sleeping on the floor of a cell that's as big as a walk-in closet in many of our homes. So I want to say we can do better. This is an incremental approach. This is a conservative approach. And by casting a vote yes today, we're going to be a better state, and we'll also be a voice for people that need a voice down here. If there's any questions, I can address them. Otherwise, I will yield the well.
There are no questions.
Thank you, Madam Speaker.
The gentleman has yielded the well. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machine. On the passage of the bill, the yeas were 162, the nays were 0. The bill, having received the requisite constitutional majority, is therefore passed.
Clerk will read the caption to House Bill 79.
House Bill 79 by Representative Gilliard to the 162nd and others, to be entitled an act to amend Chapter 4, Title 30 of the Official Code of Georgia annotated relating to rights of persons with disabilities, so as to provide that blind persons shall not be discriminated against by the courts, Department of Human Services, or a child placing agency. This bill has been referred to the Committee on Juvenile Justice. That committee recommends that this bill do pass.
Chair recognizes Representative Gilliard to present the bill.
Thank you, Mr. Speaker. About 2 years ago, in our delegation meeting, I met a great young man by the name of MacArthur Jarrett. Every year, we would get together as a delegation, and we would hear from our constituents. This young man from Chatham County happened to recommend a very viable bill dealing with parents that were legally blind, that were not able to raise their children. Today I rise to emulate Mr. Jarrett's request. And I said, Mr. Jarrett, I'll carry that bill. Last year, the bill was House Bill 891. Myself, Mary Margaret Oliver, and others were co-authors of that bill. This year, I want to thank Representative Roger Bruce for giving me the tutelage and to stand with me and 202,000 Georgians. Our Constitution is very true. It says we the people, in order to establish a more perfect union, establish justice and ensure domestic tranquility, provide for the common defense and promote the general welfare of, ensure the blessings of liberty to ourselves and to our prosperity, do ordain and establish this Constitution of the United States of America. And today we stand with Georgians in America that should have the right to parent. This individual today that you've seen patiently sitting here, along with members of the Georgia and the National Federation of Blind Citizens, Mr. Akins and others, I just want you to stand with me for a moment for this parent. Her name is Mrs. Anderson. I met her last year. She was a parent that had her rights cut from her in taking her child away. Well, she stands here today with one of her daughters, and she has another daughter that's not here, but she is a viable parent that happens to be one of those blind citizens in Georgia that's raising her child. Can we just give her a hand? Thank you, Mrs. Anderson, for what you stand for and what you do. Helen Keller best said it. Helen Keller said, the best and most beautiful thing in the world cannot be seen or even touched. They must be seen with the heart. Today, I stand here with a heartfelt fight that these citizens deserve the right to parent. If I were even going further, I'll say, oh, say, can you see? Because it's time that these individuals not be discriminated against. It's time for them to have the rights to parent. This bill truly speaks to just a simple bill giving them the rights. The Department of DHS regulates sometimes foster care and parental caretakers. This gives them the right to be caretakers, foster parents, and to be able to raise their children. Many of you, even as you sit here today, you saw Miss Anderson from afar, being that same parent, being able to say, shh, be quiet, or just be patient. So today I ask for your favorable consideration on this particular bill, Georgia's bill for Georgia's parents to have the right to parent their children and raise their children. My brothers and sisters, I ask for your favorable consideration on House Bill 79. I yield for questions.
You have no questions.
Mr. Speaker and members of the House, I yield the well. Thank you for your consideration on House Bill 79.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the passage of House Bill 79, the ayes are 167, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. The clerk will read the caption to House Bill 230.
House Bill 230 by Representative Holcomb of the 81st and others to be entitled an act to amend Chapter 2 of Title 14 of the Official Code of Georgia annotated relating to business corporations so as to provide for benefit corporations. This bill having been referred to the Committee on Judiciary, that committee recommends that this bill do pass.
Chair recognizes Representative Holcomb to present the bill.
Thank you, Mr. Speaker. It's my pleasure to present to you House Bill 230, which authorizes benefit corporations in Georgia. Benefit corporations are currently authorized in 33 states as well as the District of Columbia. And what they do very simply is they let a company have a purpose that is other than just maximizing shareholder value. There are a number of entrepreneurs who want to be able to form benefit corporations, but they currently are not available in Georgia, so this legislation is designed to fix that. The language of the bill was drafted by the corporations section of the State Bar of Georgia, and I'd be happy to answer any questions if there are any.
You have a question if you care to yield.
Yes, sir, I'll yield.
Chair recognizes Chairman Setzler to your right for a question.
Does gentleman yield?
Yes, sir.
Friendly question, simply. I've not studied this perhaps as I should. I don't understand all the provisions of it. What is the distinction that's distinct about these that gives it an additional purpose that makes it something that can't be done under existing laws?
That's a great question, Chairman Setzler. And the difference is, and what this does is it just gives companies another option in terms of how they can form themselves as a corporate entity. They can certainly still choose to be a C Corp, a classic corporation, or an S Corp, but this builds into their articles of incorporation a purpose that they will do that's other than just maximizing shareholder value. So for example, Warby Parker is a benefit corporation, and what it does is for every pair of glasses that it sells, it donates one to people who need it. And so it's not something that's optional, it's built into their corporate DNA.
So when that's, gentleman, further yield?
Yes, sir.
So when that's the case, do they get separate tax treatment, or is there a stated benefit of doing this?
There's no separate tax benefit. It's just them being able to define how they're going to do commerce in a way that they want to pursue it, and it's not optional. It's something that's mandatory, and the bill provides for requirements for board oversight on this.
Thanks, sir.
Thank you.
Do you further yield?
Yes, sir.
Chair recognizes Chairman Knight to your right for a question.
Does the gentleman yield?
Yes, sir.
I was a follow-up to the previous question, and I was just trying to look up, but it says, and please correct me if I'm wrong, or is it true that it's trying to create a public benefit, accountability. I'm looking at its impact on society and environment. I mean, what I'm trying to get is it social benefits? What is the exactly are these benefits?
If you look on, that's a great question. If you look on page 2 of the bill, the State Bar defined it as broadly as possible, and they include benefits on society, on the environment, effects on artistic, charitable, cultural, economic, ecological, educational, literary, medical, religious, scientific, social, or technological nature. So the company defines the type of benefit that they want to provide, and they don't have to. It's totally optional. It's up to them if they want to do it. But if they do, they would define what that purpose will be and how they'll do it.
Do you further yield?
Yes, sir.
Chair recognizes Representative Williamson to your right for a question.
Okay. Thank you. To the gentleman in the well, will you yield?
Yes, sir.
So help me just understand, I think I've got the gist of it about the public benefit, but what about, are they ever publicly held corporations, or are these always going to be privately held?
They are now public. Etsy is the first one, and it is an online bazaar of handcrafted goods, and it pays its it pays its employees to do volunteer work, and it does other things as well. And so there are public corporations. Many of them are private, but there are benefit corporations operating in Georgia today that had to incorporate in other states because it's not an option that's currently available for them to register as.
And they're traded on major exchange. I'm sorry, follow-up question.
Yes, sir.
So they're traded on major stock exchanges?
They can be. Yes, sir.
Thank you.
Do you continue to yield?
I'll take one more, Mr. Speaker.
Chair recognizes Representative McLaurin to your right for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, sir.
Is it not true that one of the major impacts that this bill has in advancing the public interest is that it might modify the nature of what's called a fiduciary duty of the directors of the corporation?
That's well said, Representative. Thank you.
Do you further yield?
Yes.
And is it not true that normally if the only goal of a corporation is to maximize profit, fiduciary duties might compel corporate directors to only seek profit, whereas in this type of corporation, even with fiduciary duty, corporate directors have the freedom to pursue other objectives?
That's right, in line with what they have defined those objectives to be.
Thank you.
Thanks.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no. And the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 230. The ayes are 165, the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 227.
House Bill 227 by Representative Fry of the 118th, Buckner of the 137th, Cannon of the 58th, Smith of the 41st, Wen of the 89th, and others, being entitled an act to amend Code Section 3364, the official code of Georgia annotated relating to enumeration of unfair methods of competition and unfair or deceptive acts or practices regarding insurance. This bill having been referred to the Committee on Insurance, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Fry to present the bill.
Thank you, Mr. Speaker. Members of the House, I bring to you House Bill 227. Basically, this bill just aimed to expand the discrimination protections in the insurance realm to victims of sexual assault and domestic violence. Back in 2000, we saw a wave of insurance companies denying coverage based on folks who had been the victims of domestic violence. We were able to pass a law in the state of Georgia that precluded that hindrance of coverage, and this adds sexual assault to that code section. It's part that had been left out, and we'd be the 40th state in the nation to do it. Currently, 45 states actually have domestic violence prohibition in their code section. I wish that y'all would vote for this bill in a favorable fashion, and yield for any questions.
You have no questions.
Thank you, sir. I yield the will.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 227 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 227. The ayes are 164, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 492.
House Bill 492 by Representative Rich, the 97th, and others, to be entitled an act to amend Article 3 of Chapter 7, Title 44 of the Official Code of Georgia Annotated, relating to dispossessory proceedings, so as to require applications for execution of a writ of possession to be made within 30 days of the issuance of the writ. This bill has been referred to the Committee on Judiciary. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Rich to present the bill.
Thank you, Mr. Speaker, members of the House. I bring to you House Bill 492. This bill simply provides that after one receives a writ of possession in a dispossessory, that he must present that to the sheriff for execution within 30 days of his having obtained the writ, unless he shows good cause for the delay. Most orders already provide for this 30-day time period, but the counsel for the magistrate courts would like to make this consistent across the state, so they have requested this. It should be noted that this bill is supported by the realtors and the apartment associations, and that this bill does not put any requirements whatsoever or time limits on the sheriff for service of the writ. And unless I have questions, I will yield the well.
You have no questions.
Thank you.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 492 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 492. The ayes are 164, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 501.
House Bill 501 by Representative Petrie of the 166th and others, to be entitled an act to amend Article 4, Chapter 4 of Title 27 of the Official Code of Georgia Annotated, relating to seafood, so as to provide for mariculture development. This bill has been referred to the Committee on Game, Fish, and Parks. That committee recommends that this bill do pass.
Chair recognizes Chairman Petrie to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I bring you today House Bill 501. This bill creates an entire new industry in Georgia, the mariculture of shellfish, or the farming of oysters. In Georgia, we have about a $1.7 million industry today in wild harvest of oysters and clams, but we do not have the ability today to farm oysters. This bill very simply creates the ability for people to farm oysters in the subtidal zones of our estuaries in cages, that they will float off the bottom in leased areas along our estuaries. That will be determined by the department. It allows a lottery system where we approve of vetted individuals that will compete for those leases to grow oysters. And we have a lottery system for one reason, folks, and that is to make sure that Georgia residents, and individuals that are already experienced harvesters of oysters have the opportunity, many of whom live in Representative Al Williams' district in Liberty County, have access to this farming. And so, my friends, this bill, we put a lot of effort into food safety. The Department of Agriculture, the Department of Natural Resources are absolutely supportive of it. And, Mr. Speaker, I'm glad to stand for any questions if there are any.
You have some questions if you care to yield.
Yes, sir, Mr. Speaker, gladly.
Chair recognizes Representative Al Williams.
Thank you, Mr.
To
Speaker.
your left for a question.
Will the gentleman yield?
I do, my friend.
Is it not true that the best tasting oysters in the world are Georgia wild oysters?
Absolutely. The best.
But is it not further true that unfortunately they are also the ugliest oysters in the world?
They are indeed. They grow in clumps, as you know, my friend.
And is it not true that because of how they grow, restaurants will not buy them and we cannot put them in restaurants?
My friend is absolutely correct.
Will the gentleman further yield?
I do.
In this bill, there has been some concern, as you and I have talked about, that traditional oyster growers would be put out of the system and would not have a fair opportunity to make sure that they participate in the system. And is it not true that I have been assured that under the lottery system, they will be able, and they will certainly be given due consideration, as a matter of fact, favorable consideration for having spent so much time in the oyster business?
Representative, they will be able to compete and their experience will matter in that process. That is correct, sir.
Thank you, sir.
Thank you for the question.
Do you yield for another question?
I do, Mr. Speaker.
Chair recognizes Representative Buckner to your left for a question.
Does the gentleman yield?
Yes, ma'am.
I agree. Georgia oysters are great, and I do support the concept here, but I have had some confusion about the lottery process.
Mm-hmm.
Can you explain that to me about how that will work? Whether just explain.
Yes, ma'am. Yes, ma'am. The department envisions a great deal of interest in this, and so there will be numerous individuals who will apply. They will be vetted. They all have to meet a minimum standard, and then the lottery will help to determine who is chosen for these limited leases that are available, because remember, these leases are going to encumber the estuaries of our coastal marshlands. And so they will be vetted thoroughly, everyone will meet the standard, and then there will be a lottery to make sure that Georgia residents and Georgia experienced harvesters have access, and that it isn't dominated by out-of-state large industries who can outbid those other individuals. That is the process, madam.
Does the gentleman further yield?
Yes, ma'am.
Will the farmers be able to self-select sites, or when this lottery is conducted, will they be drawn out as a person to be able to farm, but they will be told what site they will have to farm on?
My understanding is they will enter the lottery for specific lease sites.
Self-selected lease.
They will be interested in certain sites, and they will make that clear in their application process, is my understanding, Representative. Yes.
One further question?
Yes, ma'am, of course.
Will the leaseholders, once they've been given a site and gone through the lottery process, will they be able to import the seed from other places?
Yes, ma'am, they will. But here, thank you for the question. Very important question. So the seed in this bill, the seed must be from an approved hatchery by the department. And in this bill, by the way, it speaks expressly to sites that are certified with a shellfish pathologist. So one of the things that we're concerned about is protecting the waters of our coast. And so we want to make sure that we're not importing seed that is diseased. Obviously, everyone I think here is aware, oysters, if they're not careful, can have diseases. Vibrio is the one that's most prevalent. And so we have to be careful about this. And so the department, if we're going to start a new industry, we have to make sure that we're very protective of food safety and also of the safety of our natural resources. So that is correct.
Thank you.
Thank you for the question.
Do you further yield?
I will yield for one more, Mr. Speaker.
I'm going to recognize one out of order because I want to know what somebody from the mountains thinks about oyster cultivation. Chair recognizes Representative Ridley to your right for a question.
Oh, no. Oh, no.
Does the gentleman yield?
I do, to my friend.
Representative, I don't know a lot about oysters, but except mountain oysters up where we're from. But my question is this. The other night we went out and you talked me into eating one. Please tell me that these other ones that you're talking about is going to taste better, because I think that one you gave to me had already turned.
Well, listen, my family have been on the Georgia coast since the Revolution, so we have acquired a taste for oysters. And so I'm sorry you have not, but you need to wait until we grow them here, and I think you'll enjoy them just fine. Mr. Speaker, if that are all the questions, I yield the well. I ask for your favorable consideration, and I hope that everyone can take pride in creating a new industry for people on the coast of Georgia to participate and to accomplish something great going forward. Thank you.
Chair recognizes Representative Jeff Jones to speak in opposition to the bill.
Thank you, Mr. Speaker. Once again, I find myself in opposition to a bill. This is not a normal position for me. I just want to kind of start out by saying, for those of you who have heard me talk about oysters, actually since June of 2018, I have been a vocal, avid enthusiast about the need for us to grow an oyster industry in this state. Quite frankly, we have dinked around with this issue for the last 15 years. And we have not yet actually gotten to the point where we have legislation or rules and regulations in place that will allow or promote oyster mariculture. And again, as Representative Petrie indicated, oyster mariculture is actually the farming of oysters. So I'm going to jump around a little bit here and try to stay with me, please. I'll try not to confuse, but I have immersed myself in this topic, and not as a self-congratulatory thing, but I think I would label myself as the resident subject matter expert in the House of Representatives on oyster mariculture. I got involved in this back in June of 2018. Got involved because of a reporter who called me and started to ask me questions about why oystering had not grown as an industry in Georgia. I quite frankly learned more from that interview than I was able to offer to the reporter who called me. He closed that interview with a challenge. He said, "What are you going to do about it?" Well, I stepped away from that interview, and after giving a little bit of thought and doing some research, again, having learned a lot from that interview, I asked myself, or told myself, quite frankly, gosh, this is a no-brainer for the state of Georgia. We have the best tasting oysters grown off the coast of the Atlantic. We have the cleanest water along Georgia coast on the Atlantic coast. Oysters grown, particularly in the McIntosh area, have that sweet, salty taste that is ideal and is sought after by people who are oyster connoisseurs. What has happened, quite frankly, is back in the early 1900s, McIntosh County in Georgia was the king of oysters in our country. Those oysters were wild-grown oysters, and they were canned. Well, what happened is that because we depend on nature to grow those oysters, the oyster population was over-harvested, and we ran out of oysters to harvest. That coupled with the fact that consumer tastes have changed, and I don't know who among us, I certainly don't, eats canned oysters. If you put oysters in your Thanksgiving dressing, you're probably using fresh oysters bought at the store someplace, and who knows where they might have come from. So what we've done actually for the last 15 years is kind of talk all around this issue. and nothing has happened. But again, I'm not blowing my own horn here. I'm just trying to do the right thing for the people of Georgia and the people who want to grow oysters and make a living out of it. We need an oyster mariculture industry in Georgia. So the reason, again, that the problem happened with oysters back in the 1900s is, as I said, we over-cultivated. The difference, and this was an incorrect testimony that was given in the HB 501 hearing in the committee last week. A comparison was made with finfish industries and shrimping. Those two industries depend upon nature. Would you not agree to grow those products? And so there is no reason from a problem with over harvesting to close the seasons for oysters by comparison, because we're farming those products. Those products, the oysters, can be grown and will be grown if we do this correctly on a 12-month-a-year basis, no longer dependent upon nature. Yes, the overriding issue with oysters needs to be, as we deliver those products, harvest those products, and deliver them in the food chain, if you will, the food distribution network, is to be sure that those oysters are delivered safely. Kind of getting in the weeds here a little bit. This is why the environmental industry, the environmental community supports oystering so much. One adult oyster will naturally filter 50 to 60 gallons per day. One oyster, 50 gallons of water filtered per day. So the environmental community is all behind this effort of oystering as long as we do it correctly. So there are several problems with the bill that is before us. It is a bill that I initially dropped with the intention of substituting that bill with a good bill that actually will have industry support. I can say unequivocally that the bill HB 501 and its companion coming out of the Senate, SB 182, do not have industry support. Those two bills do not have the support of the environmental community. Those bills are not good bills. And in fact, if we passed that, what I would call bad legislation, with so many problems inherent into that legislation, the opportunity for us to open up that code section at a later date is going to be very, very difficult. So what the industry is telling me after they've read HB 501 and SB 182 as compared to HB 565, which I have dropped, which does have industry support, the industry tells me they would rather see us not pass any legislation this year. Let us step back, take a hard look at what we're talking about here, and be sure that when we pass legislation, when this body passes legislation, that it will be good legislation that all parties, the industry, environmentalists, and very importantly, our regulatory industries, our regulatory agencies can support. I can assure you that HB 565 meets all of those tests. One of the most critical things about oystering, as we've all kind of known about not eating oysters except in our months, right? Well, that's simply because of the temperature of the our months. There tend to be colder months. I can assure you that it's Florida, South Carolina, North Carolina, and Virginia operate 12-month-a-year oyster industries. The legislation as proposed talks about that we might maybe do a 12-month-a-year industry, but then again, we might not. What we propose in HB 565 is that we follow the National Shellfish Sanitary Program standards, which dictate time and temperature harvesting, such that when we harvest oysters in a 12-month-a-year operation, we do so that those oysters are brought safely to the market. If you think about it, shrimpers have been doing this for years. They make their shrimp catch, they bring it on board, they get it on ice, and they keep it to the proper temperature before they get it to shore and turn it over to a distributor. That's what's being done with shrimping. Florida, both Carolinas, and Virginia, as I said, are doing 12-month-a-year industries. Why that is so critical is that there is a significant investment on the part of producers who want to get into this industry. And if they do not have the solid assurance legislatively and from a food safety standpoint that they're going to be able to operate their businesses on a 12-month-a-year basis, that creates tremendous uncertainty in that business. And they are not simply going to make the investments if they're not sure that they're going to be able to actually harvest their crops on a 12-month-a-year basis. The other problem, basic problem with HB 501 and SB 182 is the lottery system. I mean, we don't award bridge contracts on a lottery. What my bill proposes is that using all the criteria that's established by the Coastal Resource Division of DNR, is that we actually predefine these areas that can be leased, that the water quality in those areas is sufficient and of a quality nature that we can grow oysters there. An individual, a producer that says, I'd like to apply for a lease in that area. That lease application is submitted to DNR, and what I propose in contrast to DNR's concern is about being overwhelmed by the number of applications, is that we simply process those lease applications on a first-come, first-served basis. Thank you. Was I smacking my lips? I'm sorry, Chairman England, I didn't bring my water. Thank you. Thank you, Chairman Dollar. I didn't mean to smack in the microphone. I guess you could hear me. In any case, what we need is to be sure that, again, we've got an industry that knows that it can have a consistency of operations, that when they apply for a lease, that lease is awarded to them fairly, not through a lottery, but through an application process handled on a first-come, first-served basis. That's the simple answer to that. Then we've also got, in order to make sure that the operators, the producers who obtain a lease, that they can obtain their raw material, their product. It's called a spat or oyster seed. HB 565 proposes, in full accordance with all safety regulations, that we legislatively allow the importation of seed from out of state. And that seed, before it is brought into state, must be certified disease-free by a seafood pathologist. We certainly don't want to bring in bad seed, if you will, into the state of Georgia. We've also limited the type of seed that's going to be brought into the state of Georgia to a seed that's called the triploid. The triploid seed is one that cannot reproduce. So if there is a bad gene in that batch, then that seed will not be one that reproduces and causes problems in our industry. Certainly we don't want to do that. The other key element that I am asking for in HB 565 is that the DNR Coastal Resource Division create an oyster mariculture advisory panel. And we're asking that that advisory panel be made of all folks in the industry, and that the things that this group is proposing be allowed to be submitted to the chairs of the various committees so that their input is actually heard. I've gone on longer than I intended to, but let me just tell you, as the industry expert amongst House members, I urge you to vote down HB 501. Let us step back, take a look, do the right thing, listen to the producers and the people in the industry who want to grow this industry, and let's do it correctly. So I ask you to oppose HB 501, and when it comes across, Senate Bill 182. Thank you, Mr. Speaker.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass All those in favor of the passage of House Bill 501 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. What purpose does Chairman Petrie rise?
Mr. Speaker, is it not true that in this bill...
What purpose do you rise?
I'm sorry, for parliamentary inquiry,
State your
Mr.
inquiry.
Speaker. Is it not true that in this bill the department expects a year-round season, however has the discretion to close that season due to safety concerns like that which occurred last week in the state of Alabama, which had to close its oyster season, its farming oyster season, due to flooding in that state? Is that not true, Mr. Speaker?
I understand that to be true.
Thank you, Mr. Speaker.
What purpose does Chairman Corbett rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that the Department of Natural Resources supports this bill?
Yes, they have communicated that to me.
Thank you.
What purpose does Chairman Rhodes rise?
Parliamentary inquiry, Mr. Speaker.
State your inquiry.
Is it also not true that we've got a DNR commissioner and a staff of biologists who are the experts for the state of Georgia?
I believe that to be true, and I believe the gentleman knows whereof he speaks. What purpose does Chairman Knight rise?
Parliamentary inquiry.
State your inquiry.
Mr. Speaker, isn't it true that the next time we show up or in the future to the Savannah Day, we'd like to be eating Georgia oysters instead of those that are grown agriculturally outside of this state?
That is very possible. What purpose does Representative Al Williams rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that from the very beginning that my question has been that will traditional harvesters be left out, particularly minority harvesters? There are few left, but is it not true that we want to be assured that Georgia historical harvesters are able to have really a little better than fair access to the leases that are coming?
I believe that to be true, and I support you in that position. What purpose does Representative Cannon rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that nowhere in the bill is it written in that traditional or historic harvesters will be a part of this?
I have not read the bill, so I can't speak to that point. All members that are voting are in favor of the bill are voting green. Those opposed are voting red. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 501. The ayes are 102, the nays are 60. This bill, having received the requisite constitutional majority, is therefore passed. What purpose does Chairman Dempsey rise?
To make a motion, Mr. Speaker.
State your motion.
I move that the rules be temporarily suspended so that a bill may be read for the first time and assigned to committee, please.
The lady has moved that the rules of this House be temporarily suspended to allow a bill to be read for the first time and assigned to committee. The clerk will read the caption.
Unnumbered House Bill by Representative Dempsey of the 13th and others to be entitled an act to amend Article 1 of Chapter 2 of Title 49 of the Official Code of Georgia, annotated relating to general provisions regarding the Department of Human Services so as to provide for the review of certain law enforcement conviction data with regard to persons seeking to become volunteers, interns, students, or employees.
On the lady's motion that the rules of this House be temporarily suspended to allow a bill to be read for the first time and assigned to committee, is there objection? Is there objection? The chair hears none, and it is so ordered. Health and Human Services. House Bill 89 will be postponed to the next legislative day. House Bill 426 will be postponed to the next legislative day. If you have signed up for an announcement, make your Chair recognizes for an announcement Chairman Timothy Barr.
Thank you, sir. Code Revision Committee meeting will happen 10 minutes after adjournment in 341. Code Revision, 10 minutes after adjournment in 341. Thank you, sir.
Chair recognizes Representative Noel Williams for an announcement.
Thank you, Mr. Speaker. I'd like to remind everyone tomorrow afternoon at 5 or 5:30 we're going to have the fish fry for Crisp County, City of Cordele at the Railroad Depot. Please come and support for fish fry. Thank you.
Chair recognizes Chairman Richard Smith for an announcement.
Thank you, Mr. Speaker. I know everybody's ready to hear this, but the House Insurance Committee will meet tomorrow morning at 8 o'clock, room 606 CLOB. Thank you.
Chair recognizes Chairman Beverly for an announcement. He waves. Chair recognizes Chairman Werkheiser for an announcement.
Thank you, Mr. Speaker, and I'm joined here with Representative Nulowitz, whose husband is actually one of the sponsors of tomorrow's Kids Chance of Georgia. It's a fundraiser. You've got a sheet on your desk. It helps the injured workers, the kids of injured workers, and would love to see you there. The information's on your desk, and while I'm here, the House Industry and Labor Committee is meeting tomorrow at 3 o'clock, CLOB 506. Thank you.
Chair recognizes Chairman Watson for an announcement.
Thank you, Mr. Speaker. Just going to let everybody know that Rural Caucus will meet tomorrow for lunch. We're going to have Georgia Federal State Inspection Service and the Georgia Forestry folks talking to us as well. See you at noon. Thank you.
Chair recognizes Representative Reeves for an announcement.
Thank you, Mr. Speaker. The Reeves Subcommittee of Judiciary and Non-Civil will meet at 9 o'clock in the morning in room 415 in CLOB. Thank you.
Chair recognizes the Chairman of the House Rules Committee, Chairman Jay Powell, for an announcement.
The Rules Committee will meet tomorrow at 1 o'clock. If you've got a bill that's come out of committee in the last several days and you have not yet presented it to the Rules Committee, you need to be there at 1 o'clock to present your bill. Thanks.
Chair recognizes Chairman Welch for an announcement.
Thank you, Mr. Speaker. The Regulatory Subcommittee and Regulated Industries will meet in room 403 today, 20 minutes after the conclusion of the code revision meeting.
Chair recognizes Chairman Fleming for an announcement.
Thank you, Mr. Speaker. The House Judiciary Committee was scheduled to meet upon adjournment today. We will not meet tonight. However, the House Judiciary Committee will meet tomorrow at 2 p.m. in room 132, the House Judiciary Committee, or upon the adjournment of the House Rules Committee, whichever is first. The Judiciary will meet tomorrow at 2 p.m., House Judiciary, or upon adjournment of the Rules Committee. Thank you.
Chair recognizes Chairman Cooper for an announcement.
Listen up, everybody on the Health and Human Services Committee. I hate to do this to you, but we will meet immediately on adjournment in room 606. If everybody will get there so we have a quorum, we will try to move very rapidly to get you out. Thank you.
Chair recognizes the Chair of the Ways and Means Committee, Chairman Harrell, for an announcement.
Thank you, Mr. Speaker. Ladies and gentlemen, the Ways and Means Committee will meet immediately upon adjournment in room 341. We have 3 measures. As long as we get there quickly, we will be done quickly. Thank you.
Chair recognizes Chairman Ballinger for an announcement.
Thank you, Mr. Speaker. Your Juvenile Justice Committee will meet tomorrow at 2:30. We do have 3 measures, one of which we will be voting upon, so everyone please come. It will be a committee day for committee members that attend. Thank you.
Chair recognizes Chairman F. Stration for an announcement.
Thank you, Mr. Speaker. The Judiciary Non-Civil will meet tomorrow with the Reeves Subcommittee at 9 a.m., the Setzler Subcommittee at 10 a.m., and then full committee at 11 a.m. All 3 meetings will be in 415 of the CLOB. 9 a.m., 10 a.m. for subcommittee, 11 a.m. for full committee, 415 CLOB. Thank you.
Chair recognizes the Majority Leader of the House for a motion.
Mr. Speaker, I move that this House stand in recess until 6:30 p.m. today, and then stand adjourned until 10 a.m. Thursday, March the 7th, 2019.
The Majority Leader has moved that this House be in recess until 6:30 p.m. today, whereupon we would stand adjourned until Thursday, March 7 at 10 a.m. All those in favor of the motion will say aye. Those opposed will say no. The ayes have it. This House will be in recess until 6:30 p.m. Then we will adjourn until Thursday, March 7 at 10 a.m. for day 28.